me duct tape without chewing gum. Bubble gum. So I have this background. It's a Thanksgiving dinner. It looks delicious. It looks wonderful. So I tried to change my background, which I do all of the time. And it broke everything. So I tried to change it off of the Thanksgiving dinner. This is the first one I clicked. And it still broke everything. So this is the background way in the corner because I'm not resizing it because I'll just break everything again. That's a later problem. Alright. Enough technical issues for one day. Let's not have any more. How was your day, guys? Yesterday. It's a new day right now. How was your day? Did you guys have a good day? Listen, I know a lot of you didn't. Michael, I know a lot of you didn't have a good day yesterday. That sucks. Let's watch some court videos. Maybe it'll get better today. Maybe. What is today? What day are we on? Wednesday. I streamed twice today. I wouldn't mind streaming twice every day. All right. New judge, Colorado. Lots of cases here. And they just keep getting worse and worse. You're still waiting for your inspectors, Kelly. Oh my God. You moved a ton of bricks. I hope they were yours. Donald's out stealing bricks again. I have to call your daughter. All right, let's just watch court videos and forget about the day, right? Yep. What's gonna break when I press play? I don't know.
Are you Ben Snell?
Oh, yes, sir. Sorry, I wasn't paying attention.
Oh, that's okay. Mr. Snell, did you see the video describing your rights?
Yesterday, yes.
Any questions for me about your rights?
No.
The charge you're facing here is disorderly conduct, a petty offense. It's up to 10 days in jail, a fine up to $300. Do you understand those potential penalties?
Yes, Your Honor.
Okay. Since it's a petty offense, the court's required at this point to modify it to a $250 PR bond. We'll return it June 1st at 9:30 in room 100.
Is it possible just to do pay it immediately? Is there a way to just pay it off or no? Do I have to show up to court?
No, you gotta show up to court.
June 1st?
June
I wrote
1st.
it down for you.
Okay.
So there you go. Take those, please. Just put them in your pocket.
Okay.
Okay, and that's court. You have court tomorrow in Larimer County. Do you know that?
Yeah, I've already kind of dealt with that.
Is he gonna get busted by the guards because he has something in his pocket? Just asking for a friend.
Okay.
That's fine. I got it handled.
All right, and then you have court on June 1st. Okay.
Okay.
All right.
Okay. All right.
Any other changes from the jail?
Mr. Wilkinson, it sounds like did not want to join us today.
Okay, we'll set him over to tomorrow.
Thank you.
Thomas, is it Keelick?
Felix? It is.
Key lick. We know a key licker. Where's legal keys? Where is he?
Yes. Wait, yes.
You can see right there.
Right in here, Mr. Keelik.
How do you pronounce your last name?
Keelik?
Okay, Mr. Keelick, did you see the video describing your rights?
Yes, Your Honor.
Any questions for me about those rights?
No, Your Honor.
The charges you're facing here include aggravated robbery, a class 3 felony is 2 to 24 years in the Department of Corrections, followed by parole, a fine between $3,000 and $750,000, menacing with a real weapon, class 5 felony, there's 3 counts there, each are 6 months to 6 years in the Department of Corrections, followed by parole, a fine between $1,000 and $100,000. Criminal mischief, a class 6 felony is 6 months to 3 years in the Department of Corrections, followed by parole, a fine between $1,000 and $100,000. Resisting arrest and obstructing a peace officer, each are class 2 misdemeanors up to 120 days in jail, a fine up to $750. And theft of petty offenses up to 10 days in jail, a fine up to $750.
But his social security number's on the dark web, Judge. Leave him go. And he wasn't trespassing, apparently. I mean, he wasn't jaywalking apparently. So, is he really that bad of a person?
Do you understand those potential penalties,
Yes, Your Honor.
Ms. Shisham?
Judge, we're requesting a cash bond in this case. Mr. Kulik is already being supervised by pretrial services for a DUI in Jefferson County. In this case, at 2 a.m, he was smashing up a convenience store with a sledgehammer. He told law enforcement that he wanted law enforcement to shoot him and that he would likely do this again if he got out. In addition to those statements and the actions in this case, Mr. Kulik now has 11 pending charges in 4 cases in 4 counties. We believe that he is a threat to community safety and believe that a cash bond is appropriate. We're asking for no contact with Dominic Paschetti and the Maverick at 1103 East Highway.
Paschetti! His last name's Paschetti. And everybody said when people call it Paschetti, they're naming it wrong. Maybe it is Paschetti. Maybe his ancestors actually created a dish. And we all call it spaghetti and we're wrong.
Highway 6 and 50 in Fruta, no weapons and pretrial services.
Ms. Heiserov?
Thank you, Your Honor. We have no objection to the no contact or pretrial services. We are asking that the court consider a PR bond for Mr. Kulik in this case, recognizing that the allegations are very serious. It is my understanding in speaking with Mr. Kulik and in reading the allegations in the case that this is a mental health situation that Mr. Kulik was in. Mr. Kulik is a veteran of the armed forces and I think has some underlying mental health issues that he is maybe not dealing with in the best way. And speaking with Mr. Kulik, his intent going forward, if the court were to give him the opportunity on a personal or cognizance bond, would to be immediately to seek help at the VA here in town. He does have pending cases. He was supposed to be at his sentencing hearing this morning in Jefferson County for the DUI case that he pled guilty in. I have been in communication with
Violet, do not smash up a store with a sledgehammer. Going 3 days without coffee makes you vulnerable to things like that. Look what happened to him.
his attorney there, and he did not receive the FTA. And I think they just rescheduled his sentencing for later this month. He also has a pending DUR and speeding case in Adams County that he's represented by the same attorney. And then that other summons case in Garfield County, the prohibited use of a weapon, that he has not yet been to court on. Currently, Mr. Kulik lives with his parents in Fruta, Colorado. My understanding from Mr. Kulik is that his parents are very supportive of him, and that they will help him get to court. Given that there seems to be perhaps alcohol that was involved in this situation, Mr. Kulik would also not object to pretrial services and testing. I do think that given that Mr. Kulik is a CPAT category of 1 with a very limited criminal history, that seems to be all related to either driving or alcohol. This is kind of the first, I would say, quote unquote, person offense that he's been accused of. I think that there are sufficient non-monetary conditions of bond that would ensure that Mr. Kulik come to court. And I think that there's no indication in Mr. Kulik's criminal history that he would not abide by no contact orders and other orders by the court to stay sober. And so we are asking that the court consider a PR bond with testing and any additional non-monetary conditions of bond that the court thinks are appropriate.
Okay, guys, what do you think? Is a PR bond appropriate in this situation?
Court finds in the review of the affidavit that Mr. Kulik poses a significant public safety risk to the community, particularly the individual involved here, for apparently no reason. The concern the court has is that repeatedly asking the store clerk to call 911 because he wanted to have a shootout with law enforcement or get law enforcement here because he's going to fight with them, smashing up things with a sledgehammer for no reason, getting the clerk to provide him with cigarettes, and telling him to not do anything wrong. The other cases may be driving cases, DUI cases, alcohol-related cases, but the court's not going to take a risk of this future behavior where somebody basically threatens a clerk and tells them exactly what he's going to do, and that is to fight with law enforcement, or even if it's an issue of suicide by cop, the only assurance that I have that that won't happen, and the conduct is to keep Mr. Keelik in custody. Court will set bond at $25,000 cash only with pretrial services, no alcohol or controlled substances without a doctor's prescription, no contact with Dominic Pachetti or the convenience store in the Maverick at 1103 East Highway 6 and 50 in Fruta, a prohibition in the restraining order from possessing, purchasing, or controlling firearms or weapons, restrained from alcohol and controlled substances subject to random testing by pretrial to assure compliance with those conditions. You're also prohibited from harassing, molesting, intimidating, retaliating, or tampering with any victim or witness. If you violate that restriction of the protection order, could be charged with a separate offense that could be a felony. Do you understand that, Mr. Keelik?
Yes, Your Honor.
Case is assigned to Judge Chaffin. Will read.
The last people I would want to fight with physically are police officers, because their mindset is, if I get into a fight and I lose that fight, I'm going to die, and a lot of other people might die too. I cannot lose a fight no matter what. No matter what. I do whatever it takes to win every single fight. Why would you want to fight someone like that?
Return it next Wednesday, May 20th at 9 for
I will try for $20 though. Just
formal filing. Would you like me to appoint the public defender's office to represent you?
Yes, Your Honor.
Okay. I'll appoint them and they'll be available on next Wednesday.
$30.
Thank you.
Thank you.
$20.
Denny Martini,
Martini?
26 CR 461.
Go back to me, Todd. Am I coming in here now?
You stood right here. Judge is on the screen.
Martini,
Shut it. You can shut it. She'll come. Oh, there she goes. She's coming back.
Mr. Martini, did you see the video describing your rights?
Yes, sir.
Do you have any questions for me about your rights?
Martini.
No, sir.
Okay. The charges you're facing here include second-degree assault with intent to cause bodily injury by strangulation. A Class 4 felony is 1 to 12 years in the Department of Corrections, followed by parole, a fine between $2,000 and $500,000. Do you understand those potential penalties,
Yes, sir.
Ms. Shisham?
Judge, the victim wanted the court
Mr. Shisham. Shh. Shisham. Shh. I feel like they're trolling us with names today.
to know that he felt very threatened. Mr. Martini's behavior was incredibly unreasonable, and the victim does not feel safe, does not think the community is safe if he is released. The people are requesting a cash bond in this case. We recognize that he scores as a risk category 1, but for a confrontation in a restaurant to result in someone strangling another person, he is clearly placing this community in danger. The defendant was described by the victim as being erratic and angry with wide eyes and dilated pupils, strangled him to the point where the victim could not breathe. We would argue that a PR is inappropriate. We're asking for no contact with Nicholas Collins, no alcohol, pretrial services, and testing.
Ms. Isero?
Your Honor, we have no objection to the no contact order or pretrial services and testing. We would be requesting a PR bond for Mr. Martini in this case. Mr. Martini does have stable housing here in Grand Junction and has the ability to walk to court. He's lived here in Grand Junction for over a year. He owns his own handyman service and has 8 clients that he works with regularly. He does have a phone. And so is able to comply with pretrial services and testing. It appears that I think there was no video that was able to be reviewed in this case, and so the officer relied on various witness accounts to determine what he believed happened in this case. I think there's the potential that Mr. Martini felt that he was acting in self-defense in this case, given kind of that it seems that things are quite escalated. I do think that given that Mr. Martini has no prior felonies and has the most recent conviction from 16 years ago, The other thing to note, Mr. Martini is very worried about his service animal. I recognize that the officer was able to bring his service animal to his home and leave him with a friend. The friend does work. And so Mr. Martini is incredibly worried about the dog being alone in the house at 95, when it's 95 degrees out. And so has great concerns for being.
Okay, this is today, or yesterday. No, the 12th, I think. There's this much of a chance it might have been on the 11th, but I think this was the 12th. Is it really 95 degrees? What is that in Celsius? 32? I don't know. It's like 32 degrees. What if it is 32? What if I nailed it? That would be crazy. In Colorado today, is that how hot it is? That can't be right. Right? Because it's Colorado. I understand. Snow is in the mountains. Right? So they definitely are, not up in the mountains. I get it. I understand. Not all Colorado is the mountains. But still, 95 degrees? That's crazy.
Being able to care for the service animal. I think there are sufficient non-monetary conditions of bond with testing and the no contact order to ensure the victim and community safety. So I do think a PR bond is appropriate.
Based upon the limited criminal history and the actions in this particular case, the court thinks that there's sufficient non-monetary conditions to assure the safety for both Mr. Collins
35 degrees Celsius. I was 3 degrees off.
and the community. That will include a no contact order with Nicholas Collins. I'm also going to include the address. Since Mr. Collins was a DoorDash driver, it's likely that he'll go back to the McDonald's for work purposes at 1212 North Avenue in Grand Junction. No possession or consumption of alcohol is part of the protection order. Pretrial services is ordered with no alcohol condition and random testing to assure compliance. Do you understand those, Mr. Martini?
Yes, sir.
You're also prohibited from harassing, molesting, intimidating, retaliating against, or tampering with any victim or witness. If you violate that restriction, you could be charged with a separate offense that could be a felony. Do you understand that?
Yes, sir.
We'll bring this back for formal filing with Judge Flynn next Tuesday, May 19th at 8:30 for formal filing.
Is this?
I didn't set it. 2,500 PR.
So you'll get out today, but you'll start next Tuesday.
All right. I think the formula is, hold on. I think the formula is you take the Fahrenheit, you minus 32 degrees, and then you multiply that by 5/9, right? Is it 5/9? Anyway, that's how you get there.
So in 1 week at 8:38,
Wait, say something.
I'll make sure you come to court.
I would definitely.
And you have to check in. Do you have a pretrial services thing for him? I don't think he knows where it is. So this is where you have to go to check in for that test.
Trey Romero.
Okay.
Okay.
I go there every day.
You go there once and give them your contact information, and then they'll tell you how often you need to check in.
Oh, okay.
Okay, so you take that, that's yours. And then court is next week in courtroom 11. But make sure you review your bond paperwork when you get out, because that's where the court date will be.
For room 11. Okay.
Mm-hmm.
All right.
Okay,
Thank you so much.
you're welcome.
Thank you.
Trey Romero.
Come in here, Mr. Romero. So you stand right here, okay? Judge is on the screen there.
Mr. Romero, did you see the video describing your rights?
Yes, sir, I did.
Any questions for me about your rights?
Yes, sir.
The charges you're facing here include felony menacing, 2 counts, class 5 felonies, or 6 months to 6 years in the Department of Corrections, followed by parole, a fine between $1,000 and $100,000. Criminal mischief and unlawful possession of controlled substances, each could be up to 364 days in jail, a fine up to $1,000. And possession of drug paraphernalia is up to a $100 fine. Do you understand those potential penalties?
Yes, sir.
Ms. Shisham?
Judge Ross Romero is asking for the 3 addresses that are listed on the protection order to for the defendant to be prohibited from those addresses. He owns the 3 homes, and his son is known to frequent them. Mr. Romero is not in favor of a PR bond. He is okay with his son being out of custody only if he's participating in drug treatment. He does have concerns about his son being out of custody because he has nowhere to stay, and he is not welcome at Ross Romero's houses. Your Honor, the people are asking for a cash bond. Mr. Trey Romero scores as a risk category 4. He has 2 felony and 7 misdemeanor convictions, 15 FTAs in a lifetime, and 12 in the last 5 years. Notably, in 26 CR 300, he posted a PR bond on March 25th of this year, then FTA'd in that case on April 28th. Here, he poses as a significant threat to community safety, using meth and threatening and attempting to assault his parents with a hatchet, a golf club, and a metal pick. I believe his parents stated, as listed in the affidavit, that they believed he would harm or kill them. For these reasons, we believe that a cash bond is appropriate. We're asking for no contact with Ross and Jody Romero, no contact with 344 North Maple Street, 332 North Maple Street, and 380 North Maple Street in Fruta. No weapons, no drugs, pretrial services, and testing.
Ms. Heiser.
Can I mute for just one moment, please, Your Honor?
Yes.
Thank you.
Don't mute everybody.
Your Honor, we are asking that the court consider a PR bond in this case with pretrial services and testing. Obviously, Mr. Romero was previously living with his parents, and so that is no longer an option. In speaking with Mr. Romero, it's my understanding that he has a grandmother who does not live at one of the 3 addresses that Ms. Shisham just provided. His hope would be that his grandmother would allow him to stay with her. He would then be close enough, he believes, to walk to court, and that could make sure that he attends court. I think previously he had relied on the assistance of his mother to get to court, and obviously that will no longer be a resource that he has available to him. Mr. Romero is not concerned about his ability to stay sober if the court does order testing and allows him out on a PR bond in this case. So I do believe that since there is with the addition of the testing and the no contact orders, that the victim safety is appropriately addressed. And so we would ask that the court consider PR bond.
Until the court has assurance that Mr. Romero is dealing with addiction issues, it's now risen to criminal conduct, including threatening those that are closest to him. The court will set bond in this case at $10,000 cash only, based upon the conduct reflected in this affidavit. The fact that he did a jail sentence for menacing on a misdemeanor in 2024. Ross Romero sought the protection of a civil protection order that was filed actually earlier this year, and things have obviously escalated since then. No possession of any weapons, no contact with Ross or Jody Romero. You're restrained from possessing controlled substances without a valid prescription. Pretrial services is ordered with random testing. No contact with the 3 addresses on North Maple Street, 344, 332, and 380. You're also prohibited from harassing, molesting, intimidating, retaliating, or tampering with any victim or witness. If you violate that restriction, you can be charged with a separate offense that could be a felony. Do you understand that, Mr. Romero?
Yes, sir.
Case is assigned to Judge Lawrence. We'll return for formal filing next Tuesday, May 19th at 8:45. Would you like me to appoint the Public Defender's Office to represent you, Mr. Romero?
Yes, sir.
Okay, I'll appoint them. They'll be available next Tuesday.
Page.
Dennis P.
Okay.
26M 1283. Yeah.
I'm desperately trying, Kelly, to think of a pickup line where I could put you in color to make it a pickup line, but no, I can't do it.
Right here, Mr. Page.
All I need is you. I got
Paige,
the
did you see the video describing your rights?
Yes, sir.
Any questions for me about those rights?
No, sir.
The charges you're facing include child abuse, not injury, and harassment. Each are Class 2 misdemeanors, up to 120 days in jail, a fine up to $750. Third-degree assault to Class 1 misdemeanors, up to 364 days in jail, a fine up to $1,000. If convicted, you'd be required to complete domestic violence counseling. You could also be ordered to surrender any firearms or ammunition in your possession within 24 hours. Do you understand that?
Yes, sir.
Mr. Craig as to Brady.
Judge Brady does apply. The named victim was notified of this hearing. She's present via WebEx and she'd like to address the court. It's Ms. Gahn.
Could you unmute her? Yeah.
Hi, Sherry.
Ms. Gahn, you're unmuted. Is it Gahn or Goin, or could you tell me how it's pronounced?
It's gone.
Like
Gahn, Ms.
gone.
Gahn. Could you state your name and spell your last name, please?
My name is Amber Gone, Gohn.
And what do you want to let me know today?
I wanted to let you know, that results of the threats and the few phone calls that I answered out of the 206 phone calls that he made to my cell phone, he threatened me and both of my children's home with a firearm. One of those is an autistic 3-year-old who will not go to school because she's scared that if he gets out, her mommy's going to get hurt. So she's too scared to go to school and has resulted in constant crying and fits and tantrums. And my 1-year-old has been staying with his dad since then, just to ensure his safety. So I ask that if he does get out and continues, just the UAs that he is somehow passing and then getting drunk and doing things, that you just make sure that there is a protection order in place for me, both of my kids, and the addresses that me and my kids will be at.
Okay, the children
So we just heard part of it, but it gets much worse real quick.
I have listed from the people include, is it Delilah Garul?
Yes, that's my daughter.
And then Slater Denny Gon?
Yes, that's my son.
Okay, I just wanted to make sure I had the names correct. And could you tell me the time frame you're talking about as far as the 200 plus calls?
They started at 2:36 in the morning and ended at 7:48 7:48 that following morning.
I mean, what's the date though? I mean,
The Monday, the
okay,
day after Mother's Day.
okay, all right. Thank you, Ms. Gon. Mr. Craig?
Judge, the CPAT's low and the DBSI, I think, is not considered
It gets worse when the judge starts talking.
elevated. The concern that people have is that he just entered into a deferred on 2 misdemeanor cases in January of this year. It was a different victim for those 2 cases. And reading the report, it seems like he started dating Ms. Gahn quickly thereafter. We are asking for no contact orders with the victim and the children, and the addresses listed, the 281-504 for both of those. We would recommend a GPS monitor, and we would be asking for cash-only bond at this point. One thing I think to be noted, though, is when he was arrested, he did not have a firearm on him.
Ms. Heiserow?
Thank you, Your Honor. We're asking that the court consider a PR bond for Mr. Page in this case. Mr. Page does deny having a gun. He recognizes that he's not allowed to on his deferred judgment. And so he has informed me that he does not have a gun. What is not included also in this report is that Mr. Page, after being called by the police that morning, did return their call. He didn't answer the initial call, but he did return their call and answered all of their questions. At that time, they did not inform him that they had sought and received a warrant. He was just on his way to work when he was arrested. I think that's notable because Ms. Gahn had claimed to the police that Mr. Page was on his way based off of what he said in his phone calls to her home. And so notably, the police did not contact Mr. Page at Ms. Gahn's home. Mr. Page has been on this deferred, I think for 2 months.
Since January.
Oh, 4 months. He has been regularly checking in with his case manager at CJSD. He's also did his alcohol evaluation and is going to AA. He goes at least once a week, but tries to also go twice a week. That was what was recommended by the evaluation when he completed it. The evaluation did not recommend further classes.
Sounds good. Give him a PR bond. Monica, thank you so much. She subscribed to Prime for 10 months in a row now. If you have Amazon Prime, you can subscribe to Twitch, my channel on Twitch, for free. You have one free one every month. And if you're watching YouTube and you get ads, you can watch on Twitch with no ads if you do that. It's the only, I'm not asking you to do that. I'm saying if you don't want to see ads, you can do that.
For the alcohol evaluation. He completed his domestic violence evaluation and he's scheduled to begin his domestic violence classes on May 28th. And so he is doing what he is supposed to be doing on the deferred judgment and sentence. Mr. Page does work full-time at Amazon. He just got Employee of the Month. He has stable housing. He's currently in a custody, I think there's a custody situation going on for his biological daughter. So he has a house that he got that could hold him and his daughter, I think in hopes that he is able to get some sort of partial custody arrangement in that case. Mr. Page is not a flight risk. He has a license and a vehicle, and so he is able to get to court. It appears that he has no history of FTAs, and so I do think that he will come to court. Mr. Page does not object to the no contact orders requested by the victim. The only request that Mr. Page has is, it's my understanding that Ms. Gahn may have a decent amount of his clothing, and so Mr. Page is requesting a one-time civil standby to figure out a way to get his clothing back from Ms. Gahn. So I do think that Mr. Page will abide by a no contact order, and so a PR bond with the no contact order is appropriate to address the concerns of the victim.
The concern the court has is he's on deferreds in two separate cases with different victims than Ms. Gahn. The relationship is reflected both in the arrest affidavit and the CPAT indicate it's a 4-month relationship, but basically as soon as I sentenced him and ordered him to do domestic violence treatment with a different victim, he's now in a situation with a relationship with somebody else that certainly poses a risk to her. And the fact that we're back here again, I still, as of this morning, do not have requests for warrants on the two deferreds. For this, the DBSI now is a 13 with serious risks, including controlling behaviors according to the affidavit and escalation. The court finds that Mr. Page poses a significant public safety risk, specifically to Ms. Gahn and her children. The court will set bond at $2,500 cash only in this case, with no contact with Amber Gahn, her two children, Delilah Garul and Slater Denny Gahn. No contact with 2680 B and a half road anywhere there, regardless of the unit. 3052 Bookcliff Avenue and 577 Tico Avenue. Prohibition against possession of firearms, weapons, and order relinquishment of those within 24 hours. Vacating the home of Ms. Gahn if there are any items that are there. You're also prohibited from harassing, molesting, intimidating, retaliating, or tampering with any victim or witness. If you violate that restriction, you could be charged with a separate offense that could be a felony. Do you understand that, Mr. Page?
Yes, sir.
We'll bring this case back next Tuesday, May 19th at 1:30 in my division. Would you like me to appoint the public defender's office to represent you?
Yeah.
Okay, I'll appoint the public defender's office and they'll be available on Tuesday.
Little lawyer to contact you. Okay.
Jacob Dowell.
Back.
Mr. Dowell, did you see the video describing your rights?
Yes, sir, I did.
Any questions for me about your rights?
No, sir.
The charge in the newest case, 26M-1287, is violation of a protection order. It's up to 364 days in jail, a fine up to $1,000. The other case is a $1,500 cash-only warrant with the allegation of the violation of the terms and conditions of probation, with the new case being the sole count in the complaint. Do you understand the potential penalties in the newest case?
Yes.
Mr. Craig, do the people wish to be heard on this case?
Yes, Judge, the people don't oppose a PR bond. We would be asking for pretrial services. No alcohol is a condition of the bond with testing.
Any objection to that, Ms. Heiserow?
No, Your Honor.
Court
That
will
would be for
authorize,
both cases, right?
yeah, that's right.
Okay.
Court will authorize two $1,500 PR bonds with the condition of pretrial services, no alcohol, and random testing. The other condition in 24M 3338 is that you report to probation within 24 hours of your release from custody.
He won't. Kelly, I just want you to know I was driving to work today when I should have been watching the road, and I about had a heart attack. I thought I missed your birthday. I'm driving down the road. Oh my gosh, I just missed Kelly's birthday. I missed it. It was just the other day, wasn't it? Why didn't she say anything? Oh, I missed her birthday. So I'm going down the road just feeling like a POS. And then I realized, like, right when I almost got to work, it's not yet. I still have time. I didn't miss it yet.
Do you understand that, Mr. Dowell?
Yes, sir, I do.
We'll bring both cases back to my next arraignment week. That'll be on Tuesday, June 2nd at 8, so I can see that you've reported to probation, okay? That'll be in
Yes,
my
sir.
Division 2.
Yes, sir. Thank you.
Samantha
Thank you.
Lomintiva, you're welcome, 26M 536.
Also, if anybody was keeping track, so you know how sometimes we watch these great cases and we put it on our calendars, and then some of you say, don't worry, Kathy, I'm going to put it on my calendar for you. We had a Mr. Peppers a little bit ago with Judge Funk, and Mr. Peppers was supposed to have another hearing yesterday, and I don't think he did. So if you were one of those people who were like, mark that on your calendar for me, I did try. I looked and I didn't see it. So I'm gonna see if there's anything anywhere, which I doubt anybody really did actually put it on their calendars because nobody actually texted me.
How do you pronounce your last name?
You could say it many ways, but lo mein tiwa.
I got
Most
it
times.
right.
Most times,
Yeah.
anyways.
Lomain Tiwa. Ms. Lomain Tiwa, this warrant was issued for failing to appear in
Yes.
Division 14. That court date was provided by a third-party motion from the treatment center that you're in that indicated that you'd be discharged today. So the court will modify it to a $1,250 PR bond since I don't have that train and tracking of notice for that court date. I assume that somebody that you're working with in a treatment center will let you know that, but I can't assure that for the purposes of keeping it a cash bond. Ms. Heisroth, is she out of there and back in Mesa County now?
Yes, Your Honor. She turned herself in on this warrant.
Okay. So what we'll do is we'll modify it to a $1,250 PR bond and return it next week to Division 14. That'll be on Monday, May 18th at 9:30 in room 100.
Okay. And can I ask a question?
Uh-huh.
So I'm going to be seeing you next week on Monday. The person that I was with whenever this,
Please don't make any statements.
oh, no statements right now? Oh, never mind. Then I'll wait to talk to you.
Okay. Probably Judge Grattan, not me. But I'll talk
Okay,
to you.
Judge Bratton. Okay.
I'll talk to you anytime, Ms. Lomain Tiwa, too.
Okay, well, thank you for that. Sorry, I didn't
You're
know.
welcome. That's okay. Gregory Perkins, 26M703.
Okay, thank you. Thank you.
Right here, Mr. Perkins.
I don't think it tastes good. I'm not.
Mr. Perkins, did you see the video describing your rights?
I did.
Do you have any questions for me about your rights?
No, I don't.
The charges you're facing here are based upon the complaint prepared by the district attorney as two Class 2 misdemeanors, unauthorized use of a financial transaction device.
We make lamb here like little lollipops. They're. I can't even tell you how delicious it is. I just can't because it's so good.
In criminal possession of a
expensive,
financial
though.
device, each are up to 120 days in jail, a fine up to $750. Bond was set with the warrant at $250 cash only. Do you understand those potential penalties?
Yes, Your Honor.
People wish to be heard on this case.
Judge, the people don't oppose a PR bond for this case.
Okay. $250 PR bond on the case. Mr. Perkins will bring you back on my next arraignment week, Monday, June 1st at 9:30 in room 100. Okay?
Thank you, Your Honor.
Talia Winkle, 26M1288.
1 second.
Right here, Ms. Winkle.
Donald, I agree.
Sorry, my bad.
Ms. Winkle, did you see the video describing your rights?
Yes, I did.
Do you have any questions
I did tell you it keeps getting worse, and this is the last case, so.
for me about your rights?
I do not.
Charges you're facing are include driving under the influence. It's up to a year in jail, a fine up to $1,000. Not having insurance is a minimum mandatory $500 fine, up to a year in jail. Careless driving is up to 90 days in jail, a fine up to $300. Illegal possession or consumption of marijuana and alcohol by an underage person, each are up to $100 fines. Violation of a protection order is up to 364 days in jail, a fine up to $1,000. Failing to notify police of an accident and hit and run, failing to remain at a scene, each are up to a year in jail, a fine up to $1,000. Do you understand those potential penalties?
Yes, sir, I do.
I think she's 17. But there's more. Oh, wow. Your husband's hometown. Maybe we'll see him.
People wish to
I
be
know
heard
it's
on
not
this
bad.
case.
Yes, Judge. The people are asking for a cash-only bond at this point. The reason why is because we have 3 prior VPOs, all of them involved alcohol, 25M 2982 and 25JD 2 resulted in her being hospitalized. The other one was with her holding a beer. She's on probation in 3 juvenile cases. There's alcohol and marijuana issues and the complaint where she tested positive. And then we have this case. So I think the community safety is high, and the alcohol, nothing else has really worked. If the court is inclined to do a PR bond or something similar, we would be asking for a SCRAM affixed prior to release. We would still be asking for pretrial services with no drugs, possession or consumption with testing, because marijuana was present in this case, and it seems to be an issue in our others.
It looks like there's a no bond warrant that was issued by Magistrate Garcia with an advisement scheduled, I think, for May 20th at 8:30. Ms. Heiserow?
I know that.
That's in 25 JD2. I didn't look up for 24 JD 190.
I think that it'll probably get set sooner.
My mouth
They
is
just
watering.
don't know that the warrant got canceled, that she's in custody. Can I mute for just a moment?
Yes.
Don't mute. They're going to tell Josh on you.
Thank you, Your Honor. We're asking that the court consider a PR bond in this case. Ms. Winkle would not object to a SCRAM monitor or pretrial services and testing. I think what's clear is that Ms. Winkle is struggling with an addiction to alcohol. And so I think the addition of a SCRAM monitor will ensure community safety as well as Ms. Winkle's safety, because it will help. I've heard from clients that the physical reminder of the ankle monitor on your person is a really good way to help stay sober. And so we would be asking that the court consider that. Ms. Winkle does currently have housing. She is a participant in the Youth in Transitions program through Mesa County DHS. That program helps connect her to services and helps pay for her housing. And so Ms. Winkle does receive a subsidy from the Youth in Transitions program that helps pay for her apartment. She does have an apartment, so she does have stable housing. She also has her mom is local and is another support for her. And I think in speaking with Ms. Winkle, she realizes that right now what she really needs to do is rely on the people that are in her life that are here to support her. Ms. Winkle has been connected with one of our case advocates in our office as well, Madison Sanders. I think previously Ms. Winkle had completed a treatment program, but she, in speaking to her, is interested in continuing in a treatment program. Her biggest concern would be if she were to stay in jail, she would likely lose her housing, given that this is a subsidy program that she has housing through. And so I think a lengthy stay in jail would very easily result in her housing and kind of make everything even more difficult for Ms. Winkle. So we would ask that the court consider the SCRAM monitor and a PR bond.
Court finds at this point in time that enough community resources have been provided to Ms. Winkle. If she was going to take advantage of that assistance, she should have done it by now and certainly wasn't thinking about her public subsidized housing by running her car into a curb at 12:30 in the morning and then denying that she was driving while under the influence to the officers. She's had multiple positive tests for alcohol and marijuana while on probation, and now we have a DUI with possession of alcohol and marijuana, again, 12:30 in the morning at 12th and Orchard, popping a tire, and then physically being seen by the officer who was there on another call, see her get out of the car and walk away from the car, and then they denied that she was driving or in the car. They were just walking on 12th Street. The court finds that enough resources have been provided to her if she was going to take advantage of that. Now it's a public safety issue getting behind the wheel of a car. The court will set bond at $5,000 cash only with pretrial services supervision, no alcohol, no driving without a valid license. SCRAM unit is a condition of the bond which needs to be affixed prior to her release. Regardless of what happens in the JD case, that SCRAM unit needs to be on. Do you understand those conditions, Ms. Winkle?
Yes, Your Honor, and I would just like to say,
You don't need to tell me anything. We can deal with it next week.
yeah,
We'll set
I
this,
understand.
we'll set this for next Monday, May 18th at 1. In my division, we'll move the 3 cases that are currently set for Thursday morning in my division to that date and time as well. So those are set for the 14th at 9, but we'll move them.
It's just such a good comfort food.
You want me to appoint the public defender's office to represent you in this case as well, Ms. Winkle?
Yes, please.
Okay. I'll appoint the public defender's office. They'll be available on your 4 cases in my division next Monday at 1.
Okay.
Thank you.
So I'll let you finish know that you're here. Okay.
God. Wait, can I talk to you for just a second?
Yep. Is that everything, Your Honor?
That's it.
Okay, thank you.
Thank you.
I'm not going to pretend I was paying 100% attention to all the cases the whole time. But I think we might have went through that whole thing with no PR bonds, but I could be wrong. I just heard a lot of denials of PR bonds. So I'm just going to pretend. I'm going to pretend I know my videos like I know my kids. There were no PR bonds that docket. I'm probably wrong. Someone's going to leave a comment, but that's fine. Comments are good for me. Okay, guys. Oof. Oof is all I can say. Oof. I love meat pies too.
The court's going to open the record in 25 CR 106. I note the appearance of Mr. Bullock on behalf of the people. I have Charles Jackson present today in person. He appears in the custody of the Colorado Department of Corrections and appears with his attorney of record, Russell Zane. We are set today for
Thanks for the cheers, Monica. Thank you so much.
a bond hearing. Mr. Zane, how would you like to proceed?
So, Judge, I had previously indicated to the court that Mr. Jackson's case is somewhat of an anomaly because he is in the Department of Corrections, but this case was initiated via warrant. That warrant was issued on November 18 of 2025. The warrant was served on December 18 of 2025. Mr. Jackson was not advised pursuant to the 48-hour rule until December 23rd. I made a request on December 23rd to convert the bond to a personal recognizance bond consistent with the standard practice in this judicial district for violations of the 48-hour rule. At that time, the people
YouTube won't even let me type "I love pasties." They won't even let me type that.
requested time to look into the issue, and the issue has remained kind of floating around until today. So at this time, I'm renewing the request for a personal recognizance bond for violation of the 48-hour rule. And I think it's particularly appropriate in this situation because Mr. Jackson is up against a mandatory release date, which is now, I understand, July 2nd of 2026. Mr. Jackson's health is such that he requires constant care. He requires very expensive oxygen treatments for his COPD. He also has a litany of other health issues, heart issues particularly, that continue to make his situation very difficult to deal with. Mr. Jackson has been in the Department of Corrections for about 18 months, serving this sentence that he's currently on. Prior to that, he was living in the Sterling area where he's been for about 20 years, receiving medical care from a Dr. Carrie McKay there with Banner Health. His intention is to resume that treatment on an outpatient basis once he's out of the Department of Corrections. So tell the court, the court can see he's sitting before you with oxygen, carrying oxygen tanks. He's advised me that these tanks that he's got to use when he's traveling are $340 a piece, and he's going to use 6 of them today. His cell in the Department of Corrections, you're going to have to remind me. It's
oxygen concentrator.
Oxygen concentrator. So there's medical equipment inside of his cell that he uses, an oxygen concentrator, to provide him with the oxygen that he needs to.
Don't worry, the prosecutor has something to say about that oxygen concentrator.
Be able to breathe.
You did. A pot pie is a meat pie, so they are almost identical.
We're coming to a point where the Department of Corrections will have no choice but to release him. It's not a parole decision; it's a mandatory release date. That's going to be July 2nd, and so. If he's not able to post bond, he's going to be a ward of the Crowley County Sheriff's Office. I don't think they're capable of addressing his significant medical needs. But that's really beside the point. I mean, the point of this is that Mr. Jackson was denied a bond hearing within 48 hours, and I know the court's routine practice is to grant personal recognizance bonds in those cases. And I would suggest that that's appropriate here. Would ask the court to convert this to a personal recognizance bond at this time. Thank you.
Thank you. Mr. Bullock?
Judge, I agree with Mr. Zane in the fact that there was a arrest warrant served on Mr. Jackson in December. He was not advised within 48 hours. Simply based upon the logistics that it was impossible to do so. There's no way for us to transport a inmate within the Department of Corrections to court within 48 hours for an advisement. The circumstances of this case are that Mr. Jackson committed a very serious assault. The very equipment he claims needs to be considered for his release was the very same equipment that he used to commit the assault with. Mr. Jackson's a dangerous man. He is serving a 2-year sentence out of Logan County. But prior to that, Mr. Jackson had a long and significant history of failing to appear. He was arrested on May 24th of 2021 for a failure to appear. Arrested November 4th through 21 for a failure to appear. November 1st, 2022, he was arrested on numerous warrants, several of which were for failures to appear out of the Lincoln County case. There was a traffic failure to appear. There was a municipal warrant for which he failed to appear. He was arrested on a Yuma County failure to appear warrant and Morgan County failure to appear warrant. There were additional prior arrests for failures to appear out of, looks like, a Morgan County. Judge, the history of Mr. Jackson's circumstances is that he's not going to appear. And I understand that counsel is requesting a PR bond, but Judge, I have to object to a PR bond purely based upon the community safety standard. Thank you.
Mr. Zane.
Judge, thank you. I just don't buy the argument that it's impossible. The DA and DOC can coordinate the service of a warrant on a person who's sitting in the Department of Corrections anytime they want to. So that is not an obstacle that is too difficult to overcome. That being said, you can't have your cake and eat it too. You bring these guys in by summons, denying many of them a right to a preliminary hearing, denying them any argument for credit for time served, things of that nature. And then in a particular case, you want to do it by warrant. Okay, if you do it by warrant, do it right. They can coordinate with the Department of Corrections and could have had Mr. Jackson before the court within 48 hours of the service of that warrant. It's not that difficult. We move mountains to get people from all over the state in front of the court. We have WebEx. Every single facility within the Department of Corrections has WebEx.
So
it can be done. DOC won't, put the effort together to do it. That's not Mr. Jackson's fault. So, I think DOC constantly gets a pass. It's constantly assumed that, we're all on DOC time. It'll get done when they darn well good and ready. That's not how this jurisdiction operates. That's not how this court operates. And when individuals are denied a bond hearing within 48 hours, like the statute requires, they get personal recognizance bonds. All I'm asking the court to do is be consistent with that. We can get into an argument about the facts of this case, about how correctional officers who were instructed not to spray Mr. Jackson with pepper spray did exactly that. Because he was not obeying them, according to them, he was walking off. Like, that's what preceded this whole incident. A guy with severe COPD who walks around on oxygen got sprayed in the face with pepper spray because he didn't listen to an order, not because he was threatening anybody, not because he put anybody in danger, but because they didn't think he was listening. The do not spray order was their own order. They knew not to spray him, and they did it anyway. We can get into all of that. I don't think any of it's relevant for the purposes of a bond hearing. The fact of the matter, or the purposes of this type of bond hearing, the fact of the matter is, Mr. Jack.
Maybe that's why. I think Tona just figured it out. Mincemeat and mincemeat are the same thing in my head. A mixture of dried fruits, nuts, spices. Look, when I hear mincemeat, my brain goes, nope. I don't even want to try it. I never want to try it. That maybe minced meat is not mincemeat, and I can separate them and try it, but I doubt it.
Jackson's innocent until proven guilty under both the United States and Colorado constitutions. There's a presumption in favor of pretrial release in this case under 16-4101 et sec. And the fact of the matter is they didn't do their job and get him advised in the time period that he was supposed to be advised in. So for those reasons, I think the people's argument falls flat. It's like, we can deny people a 48-hour bond hearing if they have a history of failing to appear. Where does it say that? It doesn't. That's not an exception to the 48-hour. So I would ask the court to act consistent with every other situation where this has come up and convert this to a personal recognizance bond. Thank you.
The judge is struggling because this guy's a bad guy, but the prosecutors screwed up royally. They did. The whole prosecuting team screwed up for months and months and months and months and months. But there might be a back door because he keeps catching charges, fighting people. But I don't know if that back door applies to this case.
The court on this record is going to make the following findings. The parties agree that this matter was initiated by an arrest warrant. That arrest warrant was issued on November 18, 2025. The return of service and service on the or service of the warrant was conducted by personal service on December 18, 2025 by the OIG investigator for the Colorado Department of Corrections. The defendant was brought before the court on December 23 of 2025 for advisement. The parties agree that the defendant was not brought to the court or to any court or before any judicial officer within the 48 hours as required by Rule 5A3. That does state that if the defendant is taken before a court which did not issue the arrest warrant, the court shall inform the defendant of the matter set forth in subsection A2. Subsection A1 does state the procedure following arrest. If a peace officer or any other person makes an arrest, either with or without a warrant, the arrested person shall be taken without unnecessary delay before the nearest available county or district court. Thereafter, a felony complaint, information, or indictment shall be filed. If it has not already been filed, without unnecessary delay in the proper court, and a copy thereof given to the defendant. Mr. Zane is correct in that most of the time when this situation comes up, it is usually local law enforcement will make an arrest. They either do not let the court know of the arrest, don't let the weekend bonds person know of the arrest, and so the person is left without going before a judge within the 48 hours for whatever reason. But typically it is because law enforcement hasn't communicated that the person's in custody. And so oftentimes it's either discovered by the court or an attorney that someone has not been brought before the court. And it would be fairly typical in this jurisdiction after the 48 hours that the court would grant bond and convert the bond to a personal recognizance bond. I'm looking at People v. Garcia, that's a 746 Pacific 2nd 560, which also talks about not only the 48-hour rule or not being brought before the court within 48 hours, but also the prejudice that there could be to a defendant for not doing so. I haven't really heard exactly what the prejudice is other than that Mr. Jackson has medical issues, that his medical issues are such that when he is released on the mandatory release date, that it sounds like maybe Crowley County would not be able to maybe meet the medical requirements that he's undergoing currently at the Department of Corrections. The court has also not heard from the people the reason for the delay, why there wasn't the ability for the OIG's office to set up an advisement the same day that it was served or within 48 hours of the warrant being served. So it's unclear to the court the reasons that the Department of Corrections did not comply with the 48-hour rule or get Mr. Jackson before a judge within that period of time. The court is going to grant the request, going to convert the bond to a personal recognizance bond. Mr. Jackson, on that bond, I am going to order conditions. One, that you sign a waiver of extradition. I'm also going to order that you follow all protection orders in effect, and that is a mandatory protection order that was issued for the protection of Adrian Callisto Lara and Mitchell Klempen. Going to require that you have no contact of any kind with those parties once you are released from and able to post the bond. You won't ultimately be able to post the bond until you well, most I guess you could sign the PR bond, but typically that wouldn't occur until after you are released on your mandatory release date. I assume where is he being housed at now?
Centennial.
Yeah.
Centennial. Okay. The court is going to set the matter.
Guys, listen.
Request.
Guys, stop. We were having a delicious, yummy food chat and chat for a while, and you guys are just going way downhill. We need to bring it back to macaroni and cheese, I think. Jeez.
30 days, or how far out do the parties want to go?
Whatever convenient with council.
I mean, I think we're going to run into the release date. It's going to happen sometime at the end of June or early July. I don't know if that July 2nd comes back any further between now and then. But sometime, I think it makes sense probably to go sometime after that. I don't think.
And Bobby didn't even shove his fruit into the conversation like he always does.
I think we could get him on a DOC transport much before that anyway.
You said, when did you say the mandatory release date was again?
Right now it's July 2nd.
Okay.
So it'll be at least by then, perhaps a few days earlier if there's more time to be added.
We have availability on both of the June dates.
Martha, that sounds delicious.
I would like to get at least some progress made in this case, because obviously once he's released, he'll have to fill out an out of custody application. That's going to delay the process another 2 weeks or 4 weeks for that to be completed. So I'll bring him back on June 23. And that will be at 1:30. If your mandatory release date moves up for whatever reason, Mr. Jackson, whether there's credit or whatever might be applied, you'll need to appear in person here in the Crowley County District Court on June 23 at 1:30. If you're still in custody, we'll make arrangements for you to appear in person. Okay. Anything additional, Mr. Bullock?
No, you're on.
Mr. Zane?
So,
thank you.
The prosecutor screwed up so badly that he's free. He's currently serving a sentence, but he's shortly done with his sentence and he gets to go free. He gets a PR bond. I mean, he still has the charges, so he still has to fight it in court. But, I'm not looking at the picture because I can't right now. But, I'm going to get that as soon as I can. I have another case going where there was a pretty big screw up. Pretty big. Here we go. This is pretty good, especially at the very end.
On 17 December 2025 at approximately 1700, I was patrolling southbound on Expressway 470.
The judge is going to tell him to move to the microphone soon. All right, so just breathe through it. I know the audio is bad, but it's just for a tiny bit.
Near Novels 43.
You're going to have to speak into the mic if you want to go to the podium or sit down. It'll just be easier for me to hear you, and I need to make sure that I can hear you okay.
Good afternoon, Your Honor. On 17 December 2025, at approximately 1700, I was patrolling southbound on Expressway 470 near milepost 43.
Pay attention to his testimony and see if you can spot his error. All right?
In lane number 2, when I observed a white SUV traveling at a high rate of speed past other vehicles in lane number 1. This location is in Adams County, Colorado. I initially observed the vehicle and visually estimated the speed at 95 miles per hour. Once I activated my radar, the vehicle was clocked in at 96 miles per hour. The vehicle did have another driver behind her that was traveling at the same rate of speed. At that point, I let go of the gas and I allowed that vehicle to pass me. Once she did, I activated my lights. After asking for her documentation, I went to write the citation, and upon second contact, she stated that there was another vehicle behind her traveling the same rate of speed, and I told her if I were capable of doing so, I would have pulled over both vehicles and issued both a citation, but I'm only one person. That's it on my end.
That's all you have?
Yes, ma'am.
Okay. Please have a seat.
All right, the officer just made a ginormous error. Did anybody spot it? He's gonna try maybe to fix it, but he doesn't know he made an error.
Do you wish to ask him any questions? All right, sir, do you have any rebuttal testimony to tell me any other information beyond a reasonable doubt that this offense occurred?
Sir,
and the person who it occurred with?
I'm sorry. Once I did pull the vehicle over, I identified the driver as Miss Roan. And she did state that she was speeding. She was trying to get away from the vehicle that was behind her, who was tailgating her. She was trying to get out of his way. And there was a stretch of traffic that was present that she was trying to get ahead of to move out of the way for the vehicle behind her to continue.
Okay, is there anything else you want me to know?
is there anything else you
All
want to
right,
tell
go
the
ahead and have a
judge?
seat. All right, based on the facts and information that have been presented by Officer Nunez, he noticed a vehicle and he identified the rate of speed as close to 95 miles per hour visually. He did pinpoint the location to be Adams County, Colorado, and the date of offense in December of 2025. Then he activated his radar and noted it be 96 miles per hour, and that he activated his lights. And he says that after asking for documentation, he made a second contact, and the person he pulled over had another vehicle traveling at the same rate of speed as them. And the officer said that I am only one person, I can't pull both people over. That was the end of the initial testimony. Upon rebuttal, Officer Nunez did say that he then identified the driver as Miss Ron. He did not give me a first name, and he did not identify the person who is seated at the table as the same person as he pulled over on the date of offense. And so I'm therefore dismissing this ticket. You are free to go, ma'am. Watch your speed, please. Officer, can you stick around for a moment? We get this nice amount of beyond reasonable doubt about the evidence. Thank you. Be safe out there, man. I'm so close. Really don't treat how to do this. I just wanted to see if you have any questions for me. You literally had to say, that's the person that I pulled over on the date, and I can't help you get there. So you were so close, but it's beyond a reasonable doubt. I can't do it for you. I will tell you, I've seen a lot less, so if you're coming down here, you got to be ready to go to hearing. Okay, well, now did you learn something? All right. And, so yeah, I just wanted to give you an opportunity if you had questions for me or wanted to ask me why I did what I did. I think you know why I did what I did. I tried to explain it in my ruling, that you did come back around, but then you didn't link the two people, and I can't make those assumptions or those leaps as the finder of fact. So, any questions? All right, stay safe out there. All right, see ya.
Okay, guys, I have a really good one now. So, while you're watching it, you think you know why it's good until something happens. And then you're like, oh my God, what just happened? Did that just happen? Yeah, it did. So nothing, what you think is going to happen isn't going to happen until we're like halfway through. And then you're going to say, what?
Seated.
Wisconsin.
Judge, he should sit back there for a little bit. I finally got that presumed everybody cleared out to realize that there were still some people that we hadn't addressed. I thought like maybe they were a victim for another case, so I hadn't got back there earlier.
Oh, all right.
Check in.
All right. You're Mr. LeSueur?
Yes.
Sorry you had to wait like that, sir.
I apologize for my tardiness. It's been a bizarre morning.
Yeah. Yeah.
So what I cut out at the beginning of this docket, this judge issued a warrant for this guy's arrest because he didn't show up for court. But there were some emails that he sent to somebody, not his attorney, obviously. Don't worry, you're going to hear about that. And he used the word locked out, locked out, locked out. And they didn't know what he was locked out of. He was locked out of the courtroom. He couldn't get in.
We consider the possibility. Well, yeah, I don't know. It has been for us too, Mr. LeSueur. LeSueur. All right. Let's see. What time was this supposed to be? It says 8:45. Why can't I find it? There it is. 26 CM 69 is recalled. That's Wisconsin versus David J. LeSueur. Mr. LeSueur present, has been present for some time. And so did I did authorize a warrant. It didn't issue. So the court recalls the authorization. There's no member of the State Public Defender's Office present in the courtroom. There wasn't at or about 8:48 as...
That's another thing. There was no attorney there. Judge got real mad, and the judge says, show cause. So he issued a warrant for this guy, and he did a show cause date for the Public Defender's Office. But he's going to go back on that. Don't worry.
Required, and now there isn't either. I wouldn't expect participation or presence now. So that's still an outstanding problem. Mr. LeSueur, so did you contact the Public Defender's Office?
I have been in contact with the Public Defender's Office several times. It gets to a certain point where they get what they need from me for the assessment. Then they talk to my wife who was here. That's as far as they go. They want a number of hours that she works per week. It changes every week. That's what we, and then they don't get back to me. My wife, me, my CCS facilitator have all reached out to the Public Defender's Office. I don't know what seems to be going on. My wife is a tech specialist. Her hours and everything varies week to week, especially leading up
Yeah.
paper, whatever.
Okay, Mr. Lister. Yeah, I appreciate that. It was yeah, I don't need that information. I'm just trying to,
Yes, I've reached out to them several times.
you did. Okay. And they haven't indicated to you an up or down in terms of eligibility. They just are looking for more information.
In my opinion, I don't know what they want. They keep asking about my wife's work hours. I put them into contact with her. She spoke to them. I do not know specifically what they want.
Okay. Weird. Yes, just so you know, Mr. Lesueur, maybe you're wondering why this is.
May I speak, Judge?
Well, you have, and you will again. You can be allowed to speak again, but like I'm speaking now. So, like, what usually happens is they put a letter in the file and it says this person's eligible or this person's not, and so that we don't have that here. And so a lot of times I think what might happen is if they don't have the information they need, they will tell the court, they'll say, we are not able to make an eligibility determination. Like, I don't even have that. So what else did you want to say?
This is a THC forfeiture case, right?
Well, it's not a forfeiture case. It is criminal.
Oh, okay, I understand that. This is a lot of time and energy being wasted. Am I allowed to move forward pro se?
Yeah.
For at least this hearing?
Maybe.
Because I'm not getting a satisfactory answer from the public defender office either. And it's becoming frustrating because this is a few grams of marijuana. In my opinion, I understand it's criminal and it's serious. But man, let's wrap this up. I could pay a ticket. You want me to go do a few months jail time? Like, I don't get it. Like,
well, let's see here.
Why do I need a public defender if I can move forward pro se?
Well, that's a different question. You don't have to have one, but that sort of question makes me a little bit more suspicious, Mr. Lesueur, in terms of, are you cooperating with what they want or need? So, and that's probably going to irritate you that I said that. So just disregard that. Do you want to represent yourself?
Today, I thought that's what I was doing because I don't know what's going on with the public defender's office. I've done everything I can.
Yeah. Okay. So forget about the public defender's office. Try to answer this question in a succinct way. Do you want to represent yourself or no? Do you want to think about that?
Will I get assistance from anyone in here?
Well, what kind of assistance?
If I make a blunder or something,
No, you won't. Right. No, there are perils to representing yourself. The district attorney is the prosecutor. She's not going to assist you. She's not allowed to. I can't assist you.
Is there any way we could sit down today and come to an amount on a fine or anything?
Well,
I feel like this has gone on a while.
It has. I agree. It has. I can't compel any sort of negotiations. Really, I can have people have a pretrial. Is there an offer that's outstanding, Attorney Toiber?
I do not see an offer that has been extended here. I see that maybe because of some returned mail.
What's your address, sir?
P.O. Box 5454.
Go out there and she can come in here and provide us with the zip code, sir. Good morning, ma'am. What's the zip code for that part?
It is 53708.
Okay, thank you. You can go have a seat in the gallery again. Okay, so now we have an address. Let's see here. Yeah, we are expending a lot of resources here. I think that's still probably okay, Mr. Lesueur. I'm just kind of going off of your impressions here, and I think you might be part of that problem because you want to represent yourself or not? I asked you that, and I don't really know what you want at this point.
No, I would like, because you asked me to come here in person today.
What does that mean? Guys, this could mean one of two things, all right? In Australia, when they say I take a tablet to sleep, does that mean like the iPad? Or does that mean a little pill that knocks you out? Friend, don't answer. Let us figure it out. And then you can tell us if we're right or wrong.
one would be here from the public.
I did,
defender's
and
office.
hang up, Mr. Lesueur, I'm not happy about that absence, and I'm going to do something about that. The people who are supposed to be here don't know that, but I'm going to do something about that. So, do you want to represent yourself?
No.
Huh?
No.
Okay.
I just don't know what to do because I don't want you looking at me like I'm not trying. I have done everything possible.
Okay.
Like I don't want to just walk in their offices and start demanding, but like they
Well,
don't reach back to me. They have not reached back to my CCS facilitator. They were on the phone before. She's telling me I have texts, I have emails, I have everything. They do not get back to me. And it's all, it comes to a standstill at this how many hours a week per week. And there's like, no, I can't just say 40 hours.
Good advice. Try not to think about it.
Yeah.
Good advice.
Okay. No, I'm not. I'm going to err on the side of you're not doing that. You're doing something wrong, Mr. Lesueur. But and you don't have you can call them. You don't have to go there in person. So we're going to try this again. I want you to call them by 3 o'clock today. We'll put this on a piece of paper, but the number is 920. What did she say?
I can't in here.
Okay.
And she needs to watch the language in the courtroom.
So
She's gonna get to talk.
are you comfortable, Deputy Batansky, just leaving that open, or would you prefer it closed?
Why don't we leave it closed?
Okay. Did you happen to hear an expletive, Attorney Toiber?
I did.
Okay. Okay. So let's suspend these proceedings, and would you bring that female party up here, please, Attorney Batansky?
Perhaps not behind me.
And so, we've suspended 26 CM 60. This is branch 1 of the Jefferson County Circuit Court. We're going to initiate summary contempt proceedings. Ma'am, what is your name?
My name is Tina Lesueur.
Okay. And Tina Lesueur, did you just, I don't know, 2 or 3 minutes ago exclaim the F word? About...
Yes. I'm trying to relay to my husband that I emailed all of the documentation to the district, or not the district, the public defender's office. And I'm trying to text him to tell you that I have email copies of my back and forth between me and the public defender, them telling me what I needed to send them, and then me sending all of that documentation. That's what I've been trying to get him to read on his text messages.
Okay. Can you, or do you recognize, ma'am, that using that word in a courtroom is entirely inappropriate?
I wasn't speaking it to you, and to be honest, I didn't realize that you heard me because he was saying that he couldn't hear me when I was saying the zip code.
Okay, well, other people present in the courtroom did hear you. It's not appropriate. I do consider it a contemptuous behavior. The court is required to respond to that to maintain the integrity of the proceedings. That's not acceptable behavior. So it did disrupt the proceedings. And so the next step in this process, ma'am, is to ask you, you've already sort of made a statement, but if you want to say anything before the court sentences you, you're welcome to do that now.
That's fine. I'll take my ticket and I'll go. I didn't speak it to any of your workers. I said it under my breath, and I didn't realize that you guys heard that because I was talking to myself, to my husband, I guess. So my apologies.
All right. Thank you, ma'am. The court sees fit to fine Ms. Lesueur, Ms. Lanita GF file, Madam Clerk, fine her $100. She does need to post that by noon today, and that's just 44 minutes from now. If she fails to do that, She will have to serve 2 days in the Jefferson County Jail without Huber. The court believes that it's a proportionate reaction to that utterance. I think if the door had been open and there had been more present, you probably would be going to jail, ma'am. You're a bit presumptuous in thinking that the court's just going to extract money from you. So just something to be mindful of in the future, ma'am. No F words during court. I mean, sometimes we hear those words, but it's via testimony and it's somehow integral to the proceedings. When you just are discharging frustration, it's just not appropriate. Understand?
Yes,
Okay. So, so ordered. Can you pay that by noon
I
today?
can.
Okay, pay that to the clerk of court's office. And I don't have an order yet on paper, but I'll draft that. Thank you, ma'am.
Thank you.
Recess and returning to 26 CM 60, Wisconsin versus David J. LeSueur. So, Mr. LeSueur, like I was saying, contact the public defender's office by 3 o'clock today. You might want to do that by telephone.
Sir, just tell the judge to take you in because she's going to blame you for this, for not checking your text messages while you're in court with the judge. She's going to let you have it. She's going to ream you out. You should really go to jail right now. Save yourself.
We'll put it on paper. It's 920-674-2800. Ask them, or apparently ask them again, to evaluate you. And you, if you want, I'm not ordering you to do this, but if you want, you could tell them that the judge is ordering one of their licensed attorneys to appear, to be present at proceedings on May 26th, that's a Tuesday. May 26th at 1:15. There's intake on that day scheduled to be taken up by this branch. And oh, by the way, intake will be, all the proceedings will be in person. I don't care if there's one on the list or 27. All intake in the courtroom on May 26, 2026, starting at 1:15. I'll call your matter first, Mr. LeSueur. Hard to imagine that a licensed attorney from the public defender's office won't be here. If that would somehow happen, we'll deal with that when we get to that juncture. And then hopefully, Mr. LeSueur, we can move the needle, as
Or
they
he
say.
could hire an attorney.
I appreciate your patience, sir. I'm not disbelieving of what you're saying. This is unusual, and I don't know what else to say at this point. Do you want to add anything else?
No.
No, he's scared to say anything.
Anything else, Attorney Toiber?
No, Your Honor, thank you.
Madam Clerk?
Nothing, Judge.
Recess. Thank you.
Okay, now we're going to move to something similar but different. And this is Indiana. We're going all over the United States today, guys.
Brooklyn liberal here. Come on up to this queue right here, ma'am. See where that microphone is? So you received the summons to appear because you did not show up to court. And my bailiff, Jonathan, filed this filing affidavit that he's a bailiff in my court, as I've already said. He's sending out summonses for jury duties directed by me. On February 27th of this year, I directed him to send out jury summonses for State v. Austin, 71 DO3 2504 F6 373. Summons was processed and mailed on or about February 27th, 2026, directing you of 54046628 for appear in court for jury service on March 19th, 2026 at 10 a.m. Summons was not returned by the court. On March 1st at 2026 at 5:05 p.m. Respondent you received an email notification to the email address she supplied of her summons to appear on March 19th. You failed to appear on March 19th at 10 a.m. as directed. On March 24th, 2026 at 11:03 a.m. Jonathan attempted to contact you at the email address supplied by you. He left a message requesting that you should contact the court to explain why you failed to appear. You did not. They again attempted to do the same thing on March 31st, 2026 at 2:21 p.m. Again, asking you to contact the court. And that if you didn't, if you failed to contact the court, you would be served with a rule of show cause. On April 10th, 2026, he again attempted to contact you by calling the phone number that you supplied. If you did not pick up, he left a phone message to contact you by the end of the day. You never contacted the court. As if your summons says, a person who is guilty of willful Indiana Code 3547.31 disobedience process of order, which states a person who is guilty of any willful disobedience of any process or any order lawfully issued by any court of record or by the proper officer of the court under the authority of law or direction of the court after the process or order has been served upon the person is guilty of indirect contempt of court that issued the process or order. So, ma'am, here's your chance to explain why you did not respond to a summons, to an email, or to phone calls.
I never received the initial summons and mail.
Okay.
So I didn't get that one.
Was the address incorrect?
The address is correct, but I just didn't never end up
returned. It wasn't returned, and so.
Well, I never ended up getting it at all. I don't know what happened to it.
Okay.
I don't know where it ended up being.
All right.
filled.
What about your email?
I don't usually check my email. A lot of it is spam mail, so I don't usually go through that. Same with my phone. When I get calls on my phone call, if it doesn't have my caller IDs,
What does it say to the county?
I didn't get any calls from that. It gives me phone numbers only. So
Monica's
if it's just a random phone number, I've been getting a few spam calls
room.
recently. So I didn't know that was you calling rather than
Okay, well, it's an obligation. You were ordered to be in court. And it's indirect contempt. I'm not going to hold you in contempt. But you could have been subject to money damages.
Yeah.
There could have been assessed a fine on you for doing that.
Yeah,
I'm going to say this to you. You'll get notification because you did receive a questionnaire, right? You didn't receive a questionnaire? You would have received a questionnaire to be in the.
Was it the first time?
I don't know, man. I don't know, but you would have been on the list. So here's my point. You're going to get called to serve on jury duty again. We're going to monitor it. And if you fail to appear, I'm going to hold you in direct contempt of court.
Well, I will show up to the next one.
Okay,
I showed
great.
up to one
That's
initially the first time last year.
But you were excused and you didn't serve on a jury.
Yeah, I know, because I didn't know that you were supposed to call the night
Yeah,
before.
it tells you to call.
I didn't know that it was supposed to be.
Then on the summons, man, call the night before.
I didn't know it was supposed to be the night before. I thought it was
It
supposed
says
to
it on when you get a summons. It says it right there.
be. I thought it was supposed to be after you were chosen as a juror. I'm trying to explain the best I can.
Right. Nothing's going to happen to you today. I just want you to understand that it's important that you respond to court orders and that you're going to walk out the door. Nothing's going to happen to you today. I just want to make sure that when you get another summons, should you get another summons to appear, and if you fail to appear, then it's going to be a lot more serious.
I'll be sure I will get it right. Be assured.
All right. All right. You're free to go. Thank you.
And you are all free to go. Thank you so much for coming out today. I really, really appreciate it. I do. We had a lot of people today, and that's really great. And thank you for the food talk. Man, I have so many things I want to eat. Yesterday I needed Cheetos so badly after the stream, so I ordered the Cheetos, what my daughter did for me. It was her turn. And they came in flaming hot, and I can't do that. You should, when you're that drunk, only close one eye and maybe put a foot on the floor. It stops the spin monster. Now you know. Now you know, guys, how to stop the spin monster. All right, guys, be good. I'll see you in a couple hours, actually. And I hope you all have a great day. Better day than yesterday. Okay? Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide.